most people know what a confidentiality agreement. It's just an agreement to keep information confidential, as it says on the tin. And it is also sometimes called a non-disclosure agreement, NDA. They can be really handy if you want to run a business idea past somebody. Now, I had a client once who had a really good business idea. It was a business process that was going to save a lot of time and effort. It was not one that could be protected by intellectual property. He had copyright in the process that he had drawn up, but if he took that process and didn't actually copy it but recreated it, then it wouldn't be copyright infringement. He couldn't get a patent, he couldn't get a registered design. And so he had gone to a government department, not in Australia, in another country, and pitched his program to them. And basically he wanted them to license it from him. Unfortunately for him, they thought it was a fantastic idea, but they didn't want to pay him for it. So what they did was they took his idea and recreated it. And they used his idea, and because he did not have any non-disclosure or confidentiality agreement going in, he couldn't prevent them from using it. So confidentiality, or an NDA, is not only about keeping the information confidential, it's also about not using the information in a particular way. So, or actually limiting the way they can use the information. So it usually says something like, I agree to keep this information confidential and will only use it for the purpose of evaluating whether or not I want to work with this person. NDAs are essential, especially if you have an innovation or a new design and you are wanting, or you're thinking that you might want to have it registered as a patent or have it as a registered design. Now, to secure patent or design protection, your innovation or your design has to be new. If you tell people about it, so you tell the bank about it because you want finance, or you tell a manufacturer about it because you want to work out, can it actually be manufactured? Is it something that is capable of being manufactured? Maybe you ask them to give you a prototype, make up a prototype for you. Simply by doing that with them, you could end up not being able to get a valid patent or a valid registered design unless you have the NDA with them first. So you can still get the patent or the design if you've got the NDA in place first. Now, I recently had a client who asked me to draft up an NDA for her. She came up with an amazing idea, which she was getting somebody to create as an app. She didn't want this app developer to create a competing product for her. I think she only wanted 6 months. She just said within 6 months she would be able to launch it and she would be fine. Now, it's important to know that with confidentiality and NDA, which restricts what you can do with the information, there has to be a time limit on it. If it can't be forever. You can't. The court cases have said you can't be, have to keep the information secret forever. So my client wanted the NDA for 6 months so that she could launch her product. Unfortunately for Susie, when she came to me, she had already told the web designer or the app designer what her app idea was in sufficient detail that he could create the app for her or anybody else. So when you're asking somebody to sign a confidentiality or non-disclosure agreement, it needs to be information that is confidential at the time they sign it. If you've already told them, then it's too late. They're not bound by it. So even if they sign it, it's not worth anything. They can just throw it away and go, well, this information wasn't confidential. You already revealed it to me without telling me it was confidential. So if you're drafting an NDA or you're getting one drafted for you, make sure the information is confidential. If it's already out there in the world, already known, then it's not confidential. So you can't make me keep a secret if it's not really a secret. If somebody else breaches confidentiality, then the person who's just signed the agreement might not have to keep it confidential either, because it's no longer confidential. So it is worth getting an NDA, especially if it's a business idea that you don't want somebody else to use. But remember, it has to be limited in time. It has to be reasonable. It can't already be known. And very importantly, depending on what the information relates to, it might have to have a geographic limitation. This is not so much anymore, but previously, when we just worked in our offices and we didn't expand over to be able to work internationally or through the internet, people were very much bound by geography. So previously, you might have a non-disclosure agreement which says that you can't make, if you were the manufacturer, you couldn't manufacture anything similar for somebody else who was within a 20-mile radius. But if it's a product that is distributed worldwide, then your confidentiality or your non-disclosure can be broader geographically. So it has to be reasonable within your particular industry. And so if it's a fast-moving industry, the time for confidentiality has to be less. If it's an industry that hardly changes very much, then the confidentiality period can be a lot longer. And so confidentiality and NDAs are very useful.